effective and certain manner, and I commend it to the House. Thank you.
The Honourable David Cunliffe.
Speaker, this bill reminds me rather a lot of the Prostitution Law Reform Bill. I thought you might be interested, and I'm being quite serious here. It's probably the most difficult vote that I've cast in my 12 years here. The issue with this bill, however, is similar. There is a practice in the marketplace that many New Zealanders feel uncomfortable about. In this case, it is covered bonds. Let us be clear about what a covered bond is. A covered bond is a vehicle by which large, wealthy institutional investors get themselves to the top of the security queue and mum and dad investors go to the bottom because they do not participate in the special purpose vehicle which extends the guarantee to the big investor. So this is a queue jumping mechanism. It is absolutely true. And like prostitution, the issue here is whether it is better because it exists to legalise it and regulate it, or to pretend it does not exist. And I might say that we've had quite an active debate within the Labour caucus about how we should handle this bill, because as a starting point, we are not enamoured of covered bonds. Covered bonds are not good for small investors at a time when we are trying to encourage mum and dad Kiwi to put their hard-earned savings, if they can afford any, into the banking system to build up national savings. We ought not do anything that would undermine that. Now, there is a counter-argument, and to be fair, it's worth repeating it, that covered bonds can extend the access of major banks to lower-cost offshore finance from large institutions which might A, lower retail interest rates in New Zealand by passing on those lower costs, which would be a good thing for borrowers, or B, might increase the margins of the bank, which would be a good thing for the bank's shareholders. But if the price of that is that mum and dad Kiwi face higher risk because they go to the bottom of the queue, their debt is overtaken by the security ranking of the guarantees to the special purpose vehicle, then there is a potential equity issue. And I want to compliment, Mr. Speaker, the officials from the Reserve Bank, and I'll name him, Mr. Ian Wolford, who has published the regulatory impact statement. In my view, it is a very cogent and competent impact statement, and it does set out the issues on both sides of the ledger here. What the bank notes is that the cover pool assets are sold to a separate legal entity, which is the special purpose vehicles, and they say in para 8, covered bonds do pose a risk to unsecured creditors. The risk arises as the assets to which covered bond holders have a priority right will not be available to unsecured creditors should the bank fall. Okay, or bank fail. Now that's the key downside with this legislation. And then the question is, if you're going to have a covered bond because you don't want these, if you're going to have legislation because you don't want unregulated covered bonds in the market, and they're happening anyway, which is the current parlous state of affairs in New Zealand, then you'd better regulate them. Well, the first question that arises is, what's the appropriate maximum level? The Reserve Bank has looked at the publications of the ratings agencies, who recommend around 10% as a cap, so no bank could have more than 10% of its asset base in covered bonds, and yet we note that Australia has a lower level of 8%. And we also note that the interests of the rating agencies will not be the same as the interests of the Crown if the Crown is here to defend the interests of mum and dad investors. So one of the issues which Labour will be looking at when this bill is at Select Committee, and we are supporting it as far as Select Committee at this stage so we can hear the arguments, is should that limit be lower than 10%? It sure as heck shouldn't be any higher. Should it be lower? What's wrong with 8? What's wrong with 7.5? What's wrong with 5? We will be very interested to hear submissions on that issue. The second key issue is, if the justification for this legislation is to regulate covered bonds and to prevent their unregulated spread throughout the market, what type of oversight should be provided? What type of regulation would be sufficient. And I note that the regulatory impact statement deals with issues like asset segregation, whether there is a clean split between the SPV and the other assets of the bank, and in Section 2, the certainty of treatment in insolvency, the clarity around and the powers of the asset pool monitor, and I ask whether behind the monitoring of the asset pool, the Reserve Bank or what other regulatory agency is going to have sufficient reserve powers to hold the system accountable. Now, Labor has not made up its mind yet whether it will support the bill beyond Select Committee. That will depend on the nature and substance of the submissions and of the advice which we've received. But we would signal an interest in ensuring that the limit for covered bonds is set no higher than the workable minimum, because we note right up front the trade-off with the interests of mum and dad investors. Secondly, we want to be absolutely sure that the three issues that the Reserve Bank has raised are sufficiently covered off. And fourthly, we will want to ensure that the Reserve Bank itself has sufficient reserve powers to make sure that the accountability in the chain is rigorous. Mr. Speaker, if those conditions were met, I imagine that our caucus could consider seeing its way clear to support the bill through on the grounds that we don't want an unregulated practice in the market, but nor do we want sham regulation, sir. We don't want the impression that we've cleaned up the Wild West but have a sheriff with no guns, or a pop gun in the face of some of the largest, most powerful institutions in the country. So that there is the argument. This is first reading. We wish the bill well on its way to Select Committee, and we look forward to receiving submissions. And I hope, sir, that those submissions will not just come from interested parties in the financial markets who have a pecuniary interest, that is, they make money out of this, but that we also hear from the representatives of consumers and from savers, because it is really important that the Select Committee gets the full picture. Thank you, Mr. Speaker.
I call Dr. Russell Norman.
Thank you, Mr. Speaker.